Good evening to everybody. Firstly, on behalf of the Federation of Telangana Chamber of Commerce and Industries, I extend my warm welcome to all the participants from around the globe to today's webinar. As a part of our institution's numerous efforts to acclimatize the trade and industry to these unprecedented times, we are glad to associate with CNICA in organizing this webinar on contemporary issues in international arbitration. Since the New York Arbitration Convention in 1959, international arbitration has provided a faster and less expensive solution than litigation in courts, facilitating sustainable development. I am confident that today's esteemed speaker, Mr. RANA, Senior Associate, International Arbitration and Litigation Group, Alston and Bird, New York, and Ms.RADHA RAGHAVAN of Counsel, International Dispute, Draper and Draper LLC, New York, will navigate us through the current issues in international arbitration. Thank you. Thank you, please.
Now may I call upon Mr. Anand to give the welcome address on behalf of CNICA.
Thank you, Ashok. Good evening to everyone, and good morning and good afternoon for those in different time zones. On behalf of CNICA and our event associate, the Federation of Telangana Chambers of Commerce and Industry, I am privileged to welcome all the participants for today's study series. The zeal and enthusiasm of the participants to the study series has been a constant source of support and motivation for CNICA to conduct the study series. In an era which is audience to the burgeoning increase in the utilization of international commercial arbitration, questions that affect the legality of the proceedings itself need to be microscopically examined. It is in the above pretext, today's topic, contemporary issues in international arbitration, has a very great significance. Arbitrability as a concept is often at loggerheads with parties' freedom to decide what should and should not be adjudicated by the tribunal. The matter becomes more complex when juxtaposed with concerns of public policy. Historically, disputes involving elements and claims of bribery, corruption, antitrust were considered to be non-arbitrable. Over the years, however, owing to the doctrine of separability, there has been a general acceptance, both nationally and internationally, that an allegation of corruption and bribery does not itself deprive the arbitrator of jurisdiction over the dispute. The pandemic has caused significant economic disruption and is expected to cause a deep global recession. Even prior to COVID-19, there was talk of an economic downturn in major economies and worrying levels of corporate debt. So the disruptions of COVID-19 are being felt particularly hard, with seemingly worse to come. There is little question that there will be a significant increase in the number of corporate insolvencies across most sectors, possibly rivaling the numbers seen in 2009 during the global financial recession. There is an imminent likelihood of international arbitration locking horns with domestic insolvency laws. Insolvency laws and procedural rules vary significantly across jurisdiction, and the approach to arbitrability can therefore vary. There exists a conflict between arbitration and insolvency in the international context. National public policy exists for national subjects, but international public policy holds constitutional validity in national laws in as much as treaties and conventions bind the domestic structures. Then, should primacy be given to statutes that govern domestic structures and parties? Where insolvency involves cross-border investments, foreign investors may have additional rights under international investment treaties or agreements. Foreign investors often will have a direct right under the IIA to commence proceedings, usually in international arbitration, against the host state for any breach of those commitments. An often used quote of the US court neatly describes the tension. A conflict of near polar extremes, bankruptcy policy exerts an inexorable pull towards centralization, while arbitration policy advocates a decentralized approach towards dispute resolution. Today's presentation will also cover useful tools in international arbitration, which enhances competence, integrity, judgment, professional expertise, logic, and specific sector knowledge, amongst other things, which determine the quality of arbitrator and representing counsel. On today's topic, contemporary issues in international arbitration, we have with us two of the young, distinguished personalities and immensely learned persons in Mr. RAJAT RANA and Mrs. RADHA RAGHAVAN, very accomplished and mellifluous speaker who will enliven the topic. May I ask a chairperson, Saravanan, to introduce the speakers. Over to you, Saravanan.
Yes, thank you, Mr. Anand. My warm greetings to one and all. We have with us today two distinguished young speakers to make their presentation on contemporary issues in international arbitration. The first speaker is Mr. RAJAT RANA, who had completed his law degree in National Law School of India University in the year 2006. Thereafter, he had pursued his higher degree in law in Stanford University and in University of Virginia. Mr. RAJAT RANA is a dual qualified, experienced litigator working on bid the company cases involving international arbitration and complex commercial disputes. Rajat previously served as a law clerk to Judge Sion Ki-Kwok at the UN International Criminal Tribunal for Rwanda and Justice C.K. Thakur of the Supreme Court of India. Mr. Rajat also worked on RAGHAVAN defense team at the UN International Criminal Tribunal for former Yugoslavia. He has appeared and succeeded in many numbers of commercial litigations involving healthcare, bankruptcy, financial services, securities, insurance, oil industry, telecommunications, etc. As far as international arbitration is concerned, Mr. RAJAT RANA represented the clients at the ICSID under the Energy Charter Treaty, unsettled arbitration rules, investor-state arbitration dispute, ICSID bilateral investment treaty arbitration, and top-level domain name disputes under the Uniform Dispute Resolution Procedure. In 2016, Mr. RAJAT RANA won the Young Singapore International Arbitration Center International SA competition. He has been accredited as a member of various internationally renowned arbitration and ADR organizations. At present, Mr. RAJAT RANA is a senior associate of Alston & Bird, a renowned international law firm. The next speaker is Ms. RADHA RAGHAVAN, who had completed her law degree in Bangalore University Law College, and she was a gold medalist for securing highest marks. Thereafter, she pursued LLM in New York University School of Law in the year 2015. She is a dual qualified international disputes counsel admitted to practice law in New York and India. Her experience includes representing clients in investment treaty arbitrations, commercial arbitrations, and litigation in the oil and gas, pharmaceutical, and infrastructure industries involving complex translational taxation and corporate laws. She has recently co-authored an article on India's recent economic measures against China, which has been published in India's one of the leading English newspaper, the New Indian Express. At present, she is the off-counsel international disputes at Draper & Draper LLC, New York. CNICA is happy to have both Mr. RAJAT RANA and Ms. RADHA RAGHAVAN to make their presentation on the topic. On behalf of CNICA, Federation of Telangana Chamber of Commerce and Industry, and all the participants, I warmly welcome Mr. RAJAT RANA and Ms. RADHA RAGHAVAN and request them to make their presentation. Thank you.
Thank you very much. I think, first of all, good morning, good evening from New York. I am very privileged to be here, and I'm very happy to see that there are 95 participants who are here today virtually. I have talked to RADHA, and I think the way we will divide the presentation is that we are going to cover 3 topics. The first topic is going to be on the corruption issues in arbitration, and then the second topic is going to be about discovery in arbitration, but not just any discovery in arbitration. We are going to talk about Section 1782 discovery which is a really interesting tool and has been used a lot more these days in international arbitration, whether you talk about investment arbitration or commercial arbitration. And the last topic would be on insolvency and international arbitration, which, as we just heard, is going to be a really interesting issue. It has been an interesting issue, and I think it's going to be more and more interesting issue over the next several years to come. So I think that said, with an overview of arbitration topics that we are going to cover, I'm going to turn over to Radha, and she's going to first talk about corruption issues, and then I'll jump in after that and walk you through Section 1782 discovery issues. And in the meantime, I am going to mute myself, but happy to answer any questions as we walk through the presentation.
Thank you very much, Rajat. Thank you to CNICA, to Saravanan, Mr. Anand, and Mr. Ashokpati for the warm invitation to be a part of this webinar and make my presentation along with Rajat. I'm very privileged to be here today, and I'm delighted to see 100 participants here and so much interest in this topic that we're going to be discussing today. Like Rajat mentioned, I'll be discussing corruption claims in international arbitration, and I'd like to jump straight in. I'll just pull up my point. Okay. So yes, so corruption claims in international arbitration. The structure of my presentation today is going to be, I'll be talking about, give you an overview of the corruption claims. Second, I'll be talking to you about how these corruption claims impact various, impact at various phases of an international arbitration, at the jurisdictional phase, at the merits phase, and what outcomes there have been. I'll be discussing a couple of cases. Thirdly, I'll be discussing what are the problems created by the corruption defense, and fourthly, I'll give you a conclusion with some guidelines on how to avoid the corruption claim defense in international arbitration. So what is corruption? And the World Bank defines corruption as the abuse of public office for private gain. In the context of investment treaty arbitrations, most forms of corruption by government officials are not relevant really, because they involve pure self-dealing on the part of government officials. Therefore, the focus in investment treaty arbitration is bribery. Now, bribery arises when there is an exchange of any kind between a public official and a private actor that results in private gain for a public official in exchange for the receipt by the private actor of public benefit. Now, what are the benefits that are gained through bribery? And the most common ones that we see are securing government contracts, securing government benefits, including subsidies, lower taxes, in-kind benefits, and licenses and other exclusive rights over which the government has a monopoly, permits such as construction and environmental permits. And one of the important benefits is time. A bribe to a public official could result in the extension of a critical deadline or the shortening of a period for the submission of a competitive bid or a public comment on a particular proposed investment. So these are broadly the benefits that are obtained through bribery. And now, how are these corruption claims affecting arbitration? And over the years, we've seen a growing number of claims arising in international arbitration. And once corruption is found, there are several legal consequences. These can have an impact impacted different stages of an arbitration, either the jurisdictional phase, where an arbitration can get dismissed on grounds that the underlying agreement is tainted, or it could affect the merits and the outcome of the dispute. Now, at the outset, I'd like to mention here that through the course of this presentation, I'll be making references to a more number of treaty cases. However, that's not to indicate that these claims do not frequently come up in commercial arbitration as well. Now, going to the first issue on jurisdiction. Most cases in which corruption was found in connection with an investment in treaty arbitrations were dismissed on grounds of jurisdiction or admissibility. Of course, this is not the same as upholding a right to terminate without compensation when there are claims of expropriation made. And I'd like to discuss two cases. One is Metaltech versus Uzbekistan, and the second is Incesa versus El Salvador. In both these cases, the tribunal dismissed the claimant's claims on grounds that the underlying agreement was tainted by corruption and hence did not fall within the definition of an investment. Now, in Metaltech versus Uzbekistan, what happened was there were some treaty violations that Metaltech alleged against Uzbekistan under the Israel-Uzbek BIT. And Uzbek's principal defense was that the tribunal lacked jurisdiction because Metaltech's investment was made and operated corruptly and violated Uzbek laws on bribery. Now, the tribunal upheld Uzbek's defense and dismissed Metaltech's claim for lack of jurisdiction. Its decision was based on its interpretation of the definition of investment in the treaty, and it was held that to qualify as an investment under the treaty, it was to be in compliance with the law at the time when it was established. Now, the tribunal found here that corruption to have existed with respect to 2 of the 3 consulting agreements, and thus, since the investment was established illegally, the tribunal declined jurisdiction. Now, the same thing happened in Incesa versus Salvador. El Salvador alleged that Incesa had obtained the concession contract through a massive fraud in the public bidding process, and thus the investment had not been in accordance with the law. Tribunal upheld El Salvador's defense and dismissed the case on grounds of lack of jurisdiction, and it did so on the international public order principle that a party should not benefit from their own wrongdoing. Now, so the 2 principles, underlying principles that we see coming out of these cases is this, that a court cannot grant assistance to a party that has engaged in a corrupt case, and a party should not benefit from its own wrongdoing. Now, on merits, particularly in treaty claims of expropriation, there's currently a perception that the evidence of corruption can be used to avoid responsibility to compensate for an expropriation. Does this mean that the state benefits from its own dishonest conduct by enriching itself at the expense of a foreign investor? I'd like to discuss this broadly in light of 2 cases. One is the World Duty Free case versus Republic of Kenya, and the other one was Vina Hotels versus Egypt. Now, the World Duty Free versus Republic of Kenya, the tribunal basically held that it had a duty to refuse to enforce the contract or a treaty claim based on evidence of corruption. This is a slightly unusual case because in this case, corruption was admitted by the claimant. And I'd like to go into this slightly in detail because it's an important decision on this subject. What happened here was WDF brought TT claims against the Republic of Kenya for breach of a concession contract, and it alleged expropriation. In the course of the proceedings, it was discovered that WDF had paid a bribe to the highest official of the state, the then president of Kenya. On this basis, respondent moved to dismiss WDF's claims on grounds that the Corrupt Act rendered the contract illegal and thus unenforceable. Claimant argued that since the bribe was paid to the president, who they contended was a personification of the Republic itself, rather than a mere agent, the contract was immune from illegality and therefore entitled to be enforced. The tribunal held that the bribe was received in a covert manner, and therefore the receipt of the bribe could not be attributed to Kenya itself. Now, another important issue that arose in this case was, did Kenya benefit from its own dishonest conduct by enriching itself at the expense of another? Now, the tribunal's answer to this was twofold. One, the acceptance of the bribe by Kenyan president enriched him personally and did not benefit the public at large. So if you think about it, the claimant's claim here was, if the claimant's claim was successful, the burden would fall on the public taxpayer. So the person enriched, which is the Kenyan president, and the person benefiting in this arbitration by getting the claimant's claim dismissed, which is the Kenyan taxpayers, are not the same. Therefore, we can say that the Kenya was not benefiting from its own dishonest conduct by enriching itself at the expense of another. Now, the tribunal also said that the Kenyan president did not personify the Republic of Kenya. Here, sometimes the cases have held that heads of states do not have state immunity and are personally liable when there are claims of corruption claims like this. Now, the fundamental basis on which the decision hinged was Lord Mansfield's principle of public policy, and this was laid down almost 200 years ago. And this principle says this: no court will lend its aid to a man who found his cause of action upon an immoral or an illegal act. It is upon that ground that the court goes, not for the sake of the defendant, but because they will not lend their aid to such a plaintiff. Now, the question here is, if a foreign investor procures an investment through bribery, is it appropriate for the state to terminate the investment without compensation? What is the impact of corruption on expropriation? So these are questions that came up on whether it was okay for a tribunal to allow a state to raise the defense of corruption and get the claimant's claims for expropriation dismissed. And would that indirectly mean that the state can take the investment without paying compensation? And we can debate, but a lot of tribunals have held that these corruption claims are liable to be considered, and then they have to be we will have to see how that plays out here. Now, let's take Vina Hotels versus Egypt, for example. One of the issues brought up by Egypt in this case was an allegation of corruption by the claimant. They alleged that the chairman of Egypt's hotel company was also advising Vina. These corruption allegations were not proved, and the tribunal held that it was reluctant to immunize Egypt from liability in this arbitration because the government of Egypt, despite being aware of the consulting agreement that allegedly was used to conceal corrupt payments, had decided not to prosecute the consultant. Now, another issue that came about here is, was it required for the claimant to have, for the state to have prosecuted in order to raise this defense? And I will be discussing this in the next part, which when I deal with problems created by the corruption defense. But for now, let's leave it at this. Now, what is the effect of a tribunal overlooking allegedly corrupt agreement? It would be liable to be challenged in the local courts on public policy grounds. Therefore, can an arbitral tribunal inquire into the issue of corruption sua sponte on its own? Now, the result of a tribunal, as I mentioned, overlooking this is often challenged on public policy grounds. And here I'm referring to substantive public policy, which goes to the recognition of rights and obligations by a tribunal or enforcement court in connection with the subject matter of the award. This being the case, in arbitrations where neither party alleges corruption, but evidence leads the tribunal to suspect corruption, can the tribunal go into it on its own? The answer to this is not absolutely clear, but there is a growing sense that this is permissible and that the tribunal would not be overstepping its mandate if it did so. Now, moving to the next part of my presentation, what are the problems created by the corruption defense? There are several, but I'll be dealing with three mainly today. One is the problem of burden of proof and standard of proof. The second one is the problem created by an intermediary contract. And the third is the perverse incentives problem. Now, in the burden of proof, going to the burden of proof problem, the burden of proof is always on the investor in investment treaty arbitrations. In Metal Tech, for example, the tribunal placed the burden of proof on Metal Tech. And relevant Uzbeki officials were not subject to the prosecution before the issue was raised in the arbitration, and the issue was raised here sua sponte by arbitrators, by the way. And in World Duty Free, the investor admitted to making the bribe, and this kind of evidence is rare in corruption cases. Now, after an expropriation, a foreign investor often has limited access to relevant information concerning alleged bribes. For example, foreign investor may not have access to local files. They would not have access to their local employees, local agents. States could have cut off foreign investors' access to these documents. Investments may have been made so long ago that the employees that were there at that point of time are no longer there. So there are several problems when it comes to an investor having access to this information in order to prove their to prove corruption or to prove their defense against the corruption claim alleged by the state. Now, in such situations, there's always a risk that states could make unsubstantiated corruption claims against the investor as a way to get the claims dismissed. Now, when I come to this problem of intermediary contracts, we first have to discuss what these intermediary contracts are. These intermediary agreements are agreements under which an intermediary or an agent is engaged by his principal to assist in procuring for the latter a government contract or a license or a permit. Now, in exchange of securing this contract, they are given some commission, and these agents are tasked with things like conducting market research, negotiation with government officials, developing relationships with these government officials in exchange, and they get a commission for this job. But a part of the payment would include a bribe. So it's really hard to say what part of the commission was a bribe. It's hard to prove these things. And to add to these intermediary agreements have fairly standard clauses with an arbitration clause. So when agents are not paid, principals suffer because the agents did not perform. Parties go to private arbitration. Now they opt for arbitration over litigation because of the availability of confidentiality in private arbitration. And there they make allegations that the commission was not paid, but there's a lot of silence on what the task was and why they were being paid so much commission, what part of the commission involved bribes. It's very hard to prove these things. And the difficulty in proving corruption in connection with an intermediary agreement lies in demonstrating this impropriety involved or an intended impropriety in this manner in intermediary agreements. Now, I want to also discuss another problem when it comes to corruption defenses, and that is the perverse incentives problem. And this is specific to investor-state arbitrations. Now, there is a risk that allowing states to invoke corruption as a total defense to an expropriation will create perverse incentives for the state. I discussed this a little earlier, how it works. Can states take investment of the claimant without, and then get the claimants' claims for expropriation dismissed just because they have a corruption defense? How does that work? And this is exactly the perverse incentives problem. If corruption allows expropriation without compensation, then states have an incentive to tie foreign investment to corrupt payments. If the investment is unsuccessful, burden falls on the investor. If the investment is successful, the state has a free option to take the investment without compensation by virtue of the bribe. In this way, it has the potential to be a double-edged sword in the hands of the state, and it could harm the investor whichever way. So now I'd like to conclude by saying corruption claims have a rather dampening effect on parties' legal rights under an agreement, and parties would want to take steps at every stage to ensure they avoid this corruption claim. Some of the steps they can take are training local employees on corruption, not to offer gifts to government officials, reporting any requests for gifts to third parties in connection with an investment, adopting a strong anti-corruption compliance program, setting up internal investigations to determine if there is any exposure, and so on and so forth. So if claimants are able to take these steps when they're about to make an investment or when there's already an existing investment, it would go a long way for them to be prepared in case such corruption claims come up in arbitration, or when tribunal themselves sua sponte bring up the issue of corruption in arbitration. So I'd like to end my presentation here, and I'd give the floor back to Rajat to take us through the 1782 discovery procedures. And it was my privilege to address you today. And if time permits, we'll address the insolvency and arbitration issue as well after the 1782 discovery procedure. Thank you.
Thanks, Radha. I think just one comment on the corruption stuff before I quickly walk you through.
Mr. Rajat, you need to unmute yourself.
All right, I did, sorry. So I think what I was saying is that I think it's, before I jump to the 1782 part, I think it's important that we contextualize just briefly the corruption issue, because, you know, there are a lot of us here today who are lawyers, practicing lawyers, who are law students, who work for companies, and I think given all these roles, I think it's really important to contextualize why does it matter, and that's the question I always ask myself. Why do I care about corruption issues? And I think you care about corruption issues because if you are someone who works for a company, if you're a lawyer who represents a company, that's an issue that can gut your arbitration claim, no matter how precious your arbitration claim is. And I think and it's something that you don't have to do or deal with when you're actually in the arbitration. It's something you need to proactively address by making sure the company, whether as an in-house counsel or as an outside counsel, has sufficient compliance policy. Because I can tell you that having litigated these two massive arbitrations where corruption issues were involved, the first question you ask is whether there were sufficient compliance policies for the company. And then the second thing is the other things you need to care about once you move forward in your process and you're thinking about starting an arbitration is just making sure that there are no red flags. And by red flags, I mean that, you know, just working with your local counsel wherever you are. So especially if you work in a high-risk jurisdiction, and I think India is considered to be a high-risk jurisdiction, same way as Eastern Europe or Central Asia, you always ask for, in those jurisdictions, were there any red flags? So I think, so it's really important to contextualize what stage of the proceeding you are, whether it's pre-arbitration, during the arbitration. And with that said, I'll quickly jump to Section 1782 discovery, and I'm going to try to share my screen. Let me see if I can succeed in doing that. I guess you can see this screen, right? So, okay, let's see. So I'm going to take the next 10 minutes, or hopefully less than the next 10 minutes, to walk you through Section 1782 discovery, which is a really important tool, and I would like to again contextualize it. So if you are someone in, you know, for example, you're litigating a case in Delhi or Bombay or Chennai, or wherever, whatever jurisdiction in India, let's say, and you have a case where you're working for a company or an individual and you're litigating a case in India, and then while you're working on a case, you realize that, well, for the purpose of my dispute, I realize that this company that I'm against also has an office in US. And it's possible that there are documents in the US that might be helpful for my dispute in India. How do I get those documents? How do I get testimony from someone sitting in the US that might be helpful for my client in India? So US is very unique, and I think the US is very unique compared to any jurisdiction in the world, which allows the use of discovery and has empowered US courts to help litigants in foreign proceedings to come to US courts and say, hey court, I need documents. There is someone living in New York, there's someone living in California who has documents that I need for my lawsuit in India. And then I'll walk you through what those factors that the court look at, and I think that's where 1782 tools come in. So, and I think the first thing that you all need to understand, I'm sure in the Indian context, discovery is very common, but in the US, you know, I guess it's the curse of US litigation, because everyone who is in litigation in US is really scared of discovery. I mean, I think you're terrified of discovery because US courts really allow very broad discovery proceedings. Discovery can be extremely expensive because sometimes you end up producing millions of documents related to a dispute. And discovery also means that I can, you know, get a testimony. So even before the case has moved substantially over in the case, you can basically seek to depose a CEO of a company or a CFO of a company, and a lot of times these tools are used as a settlement mechanism. And I think for some reason, over the last few years at least, I've seen that 1782 discovery has been used a lot by foreign litigants as a tool for settlement pressure, as a tool to get really key documents to develop your case theory. And you can actually seek discovery even before you decide to file a lawsuit in India. So the standard that the courts use in the US is, because you have to show that there's a foreign proceeding, but in the US, if you come to New York court and say, you need discovery from me, and the court will say, but hey, you haven't really filed a lawsuit against Rajat in India. Why do you care about discovery? But all you need to show is the standard that the court has used in New York is a twinkle in the eye standard. And then the standard basically means that if you can show a good faith basis, so if you have a board resolution saying we need to hire RADHA or some law firm in US or India to start a lawsuit, or we have a board resolution saying we need to bring a lawsuit against Rajat, the court will say, yes, that's sufficient to show that you have the proceedings are in contemplation, that you're thinking about bringing those proceedings. So again, I think I already covered this, the why you need this 1782, and I think there are three scenarios where you can consider this 1782 tool. One is the investment treaty arbitration, and the second is the contractual arbitration. And of course, I'm sure everyone here is familiar with what the two distinctions are, but just to quickly summarize, investment treaty disputes are between a private entity or an individual and a sovereign state or a government entity sometimes. And then the second is a contractual arbitration, which a lot of us are familiar with, where there are two private entities engage in arbitration process based on a contract. And these two distinctions, investment treaty arbitration and contractual arbitration, are basically really fundamental to your 1782 application. So, and I think, and then the third category is litigation. I think litigation is easy. If you have a litigation in India, London, wherever, you come to US court, you say, hey, Your Honor, there's a foreign litigation in India. You quickly satisfy that criteria, which I'll just walk you through. But when it comes to investment treaty and contractual disputes, there's a huge disparity in US whether investment treaty tribunals are considered tribunals for the purposes of 1782 versus contractual dispute. So I would say it's $1 million question. And now that's on its way before the US Supreme Court. And if the US Supreme Court accepts that writ petition, we should anticipate a decision by, early next year on the question of whether 1782 can be used as a mechanism for discovery or not. But once again, it is a tool which is a pre-trial or pre-litigation tool. You can use this discovery to assist your clients even before you have filed a lawsuit, actually, which is something that's not available anywhere, I think, as far as I know, and stand to be corrected. And I wanted to put one more context is that I'm sure a lot of you have read the news about a dispute that Indigo has right now, Indigo Airlines, and they actually resorted to 1782 discovery in the US. And they're trying to seek this discovery in Florida, and there's a dispute in the LCA arbitration seated in, I think, in London, and they're trying to get discovery, 1782 discovery from the founders related to a shareholder dispute. So hopefully you are clear about the context of 1782, why we need 1782, and when you can use 1782. And now I'm going to bore you, but not too much, hopefully, with the actual, the factors. And so the 3 points on this issue is 1782 allows you discovery, both document and testimonial discovery, for proceeding in foreign or international tribunal. And this is where, when I was asking, or just quickly telling you about this $1 million question, whether investment treaty or contractual dispute is an international tribunal, that's something that's very highly litigated in the US. The US courts use 1782 very broadly. And in giving 1782 discovery, we basically have two categories of tests that you have to satisfy. One is a statutory test. If you satisfy, then you go to discretionary, where the judge will say, okay, you checked, you satisfied these, 3 factors that I need under the statute. But now let me use my discretion and see if I should really grant a discovery or not. And the way courts use their discretion depends on the jurisdiction you are in the US. So what I did was to give you an overview of the US jurisdictions very quickly, because it can be very complex. And I remember when I first came to the US and I was trying to understand different jurisdictional issues, it's really complex civil procedure wise, but I'll give you this overview. So on this presentation, you will see these numbers. Basically, since 1782, Section 1782 is a federal statute. Means it's enacted by the federal government. It's not a state statute like New York. You have to go before federal courts. In the US, we have federal courts and state courts. And what United States do is that they have divided all different states in different jurisdictions, federal jurisdictions. So, and they're called the appellate jurisdiction. Like in India, we have high court. In US, we have circuit courts. So we divide these into First Circuit, Second Circuit, Third Circuit, so you'll see all the way to 11 circuits. And the irony is that all these different circuits have a different jurisprudence on the use and scope of 1782. So depending on, so if you have a company that you want to seek documents from, and the company is actually has offices, in 2 places. So if you, for example, want to go after Bank of America and you realize it's in North Carolina and also in New York, you can actually file your lawsuit in both jurisdictions, depending on which is a favorable jurisdiction, which as a lawyer and as your lawyers, you will do that, cost benefit analysis in the best interest of your client. And then, so basically, as I said, walking through the next steps just quickly, the first category of tests I mentioned that I said these are the statutory factors is, one, you have to show that a person you need discovery from lives in the jurisdiction. So if I live in New York, the first test, whether I reside in New York, satisfied. Second, you have to show that you need discovery for use in a foreign proceeding. So you will tell the court that I need this documents or Rajat's testimony because I have filed a lawsuit against him in India, and this discovery will be used for the lawsuit in India. Easily satisfied. And third, you will say you have to show to the court that you are an interested person. Basically, if you see there's a dispute in India, let's say between Reliance and the government of India, and you want to come and seek discovery from me because I have some news articles related to Reliance in India, you cannot satisfy that test because one, you're not an interested person in that dispute, because a journalist, let's say hypothetically, who wants some newspaper articles, which I have possession of for Reliance India dispute, is not an interested person for that dispute. So as long as you are an interested person, you are involved in the litigation, you easily satisfy those three factors. So you can see these factors are not very complex to satisfy, and you can quickly and easily satisfy those factors. The problem comes in with the discretionary factors, because that's when things get a little tricky. So when we talked about the discovery statutory factors, and just going back to the chart of the jurisdictions, here I mentioned that you have to live in the US or in that jurisdiction to get documents from. Last year, the federal court in New York issued a really broad opinion and basically said, look, as long as you have an office in New York, even if, say, Bank of America has an office in New York, but the document you need is not in New York, it's in, let's say, Iceland, the court has jurisdiction to order discovery. It doesn't matter. So the extraterritorial scope of 1782, which was in question for a very long time, was decided by the federal court, the Second Circuit in New York. That's the court in New York. And the court basically said, yes, you can seek discovery if a company is based in New York. Even though the documents are not in New York, you can get that discovery. So you can see how broad the discovery process is and how far you can go to get those documents for use in a foreign proceeding. And now coming to the last point about discretionary factors. So as I said, just to tell you again, there are statutory factors, which means that are actually in the legislation. The statute says 3 factors, which we walk through, and I'll show you these 3 factors. And then the courts have developed these discretionary factors. And then the court will say whether these factors are satisfied or not. And the easiest one is actually the last one, and also the most litigated one, where judges use a lot of discretion, which is whether this is unduly burdensome request. So if I go to Bank of America and say, I need all documents for the last 60 years that you have with you, the court will say, this is insane, this is unduly burdensome. So you have to make sure that your request is reasonable. You need documents from X date to Y date and related to ABC person. Most likely you will satisfy that factor. And the second is you have to show that you're not trying to really avoid. So if you have a litigation in India and then an Indian court say you cannot get discovery because of privilege issues in India or because of some other bank secrecy rule, and you come to New York, you basically avoid that privilege issue, the court will say, I see what you're doing. You're trying to be over smart and you're trying to circumvent, which is the factor here, a foreign proof gathering restriction. That factor goes against you. I mean, and then the third, I'm going back, bottoms up here from easy to difficult, is the receptivity. So if the whole exercise falls apart, and this often happens when you're in Chinese courts, where Chinese litigants come and try to get discovery in the US, for example, and it's just an example. You get discovery but in the US, but if you cannot show that the discovery that you're getting here can be used in a foreign court, that factor again goes against you. So a lot of times it's very difficult to use 1782 discovery in Chinese courts. In the same way as it's difficult sometimes to enforce arbitral awards in Chinese courts. But the receptivity of a foreign court or arbitral tribunal is very important. So far in my experience, I would tell you, just summarizing this, right now I'm involved in a 1782 process where we have actually a treaty arbitration against Lithuania, and just 2 weeks ago we won the 1782 order where we are alleging that Lithuania expropriated assets of the investor. It's one of the largest banks in Lithuania, and in expropriation process, they used a consulting company as an advisor, which is based in New York. So we are trying to actually get documents from that consulting company, and also the deposition testimony of that company's CEO. And then the court awarded us or order discovery in that process. So you can see how US courts are very open to that as well. And in the same way, I'm also representing a Chinese company that's opposing 1782, and my brief is actually due today, where there are proceedings going on in Hong Kong and the Cayman Islands courts, and the opposing side is trying to get wire transfer records from all 15 banks in New York. And they're saying that we need all these wire transfer information for a whole year, notwithstanding the fact that we are competitors in the Chinese market. So the bottom line is it's a lot of fun. So, and just these quick points, which I already mentioned about extraterritoriality, that doesn't matter if the documents are not in New York, you will get them. The last point I will mention is that if you think that you have a really losing argument that, you know, the courts are likely going to grant 1782, the statutory factors are met, the discretionary factors are met, one thing you can consider is if you can show that the discovery is sought in bad faith. So if you're trying to harass someone, or if you're trying to seek discovery in bad faith, it's very important, because in US, courts really treat the duty of candor, a lawyer's ethical duty to the court, a professional responsibility to the client very seriously. So if you file a 1782 petition and you do not disclose to the court facts properly, or which are relevant to the case, the court can say that this is in bad faith. And I have seen cases where courts have denied discovery, and the recent one was actually where the government of Turkey has been trying to seek documents in New Jersey from this guy, and the court said, look, all factors are satisfied, but I cannot possibly imagine giving you documents, because I know, Turkey, you're going to use these documents to criminally prosecute this guy back in Turkey. And if I give you these documents, you are going to violate this guy's right against self-incrimination. So the court denied discovery, notwithstanding the fact that all of these factors were satisfied. But that said, I think that's a very nice, hopefully a short summary of 1782. And if you have any questions, I'm more than happy to answer them now, or you can email me later and I'm happy to get back to you. Thank you.
So Rajat, actually, you can go to the next topic also, and then we'll come back insolvency aspect, or how do you want to proceed?
Sure. I think the fact, since we don't have a lot of time, but I think Radha and I talked about, I'm going to see if we can stop sharing. We talked about insolvency, and I think the only thing we would mention is that insolvency, as you can all imagine, is a really complex issue. It's an issue that I'm actually right now dealing in one of my arbitrations against an African sovereign state right now, and it's crazily litigated. And you know, obviously, when you, as you know, in the beginning, we mentioned that in the COVID world, we are going to see a lot of insolvency these days. So, as again to contextualize, and then you can probably laugh about it that I love contextualizing. That's going to be a question for all of us. that if a client comes to you and say, well, I really want to bring this dispute as a commercial arbitration, forget about investment grade arbitration, but I am probably going to be insolvent, what do you tell your client? But that's it, then, you know, because what you're seeing here is that you have, it's a domestic law. So let's say in this case, we have an Indian company that has a dispute, a commercial dispute with a different entity, and the arbitration is seated in London. And you start the arbitration, and 5 months later, the company goes insolvent, the liquidator is appointed, and the liquidator says, I don't recognize you guys as a lawyer anymore. Because guess what? The other side paid me nice money, and I'm going to say no to this arbitration. What do you do? And I think, and that's precisely some of the questions we are seeing these days coming up, because especially when you have an investment treaty arbitration. In investment treaty arbitration, you bring an arbitration, as you know, under an investment treaty. And in those cases, you have both domestic law and international law. And in those cases, what happens is that tribunals, at least in one case, it's a case called Carnegie versus Guinea. And in that case, it was in the first stage, the plaintiff or the claimant won the arbitration. It was challenged in exit for annulment proceedings. And the annulment committee said, we don't care about the insolvency proceedings in Guinea because this is an arbitration under exit rules, under exit convention. International law applies, domestic law does not apply here. So they disregarded insolvency proceedings. And of course, it's a very different scenario for exit, I think, because if you are an arbitrator, I'm sure you're thinking, well, if I'm an arbitrator, the last thing you want is your award to be set aside. And it's different. If you're on exit, there's no challenge to your award in domestic courts. So if you have an exit award and the exit tribunal says, we don't care about domestic law, it's fine, it's easy because it's not going to be challenged, and domestic courts, when you're enforcing, is good. But if you're in a commercial, New York Convention governed arbitration procedure, what happens there when during the course of arbitration, claimant is declared insolvent? And I think that's a question, that's an open question. We are still trying to figure out, there's a lot of debate about the choice of law issues, which, you know, I think we can talk for weeks here. And there's also a debate about that what happens even before you file arbitration, what happens then? And I think it's a lot different. So if before you file an arbitration, you're declared insolvent, I think there are serious questions whether the arbitration agreement is even valid anymore, because, you know, the entity that actually signed the arbitration agreement is defunct. What do you do then? But I think it's a lot different when in the course of arbitration, you're declared insolvent. So the solutions sometimes you provide to your client is that you can think about third-party funding. A lot of times funders actually take equity in a company, give a lot of investment, and then they decide to move forward with the case. But those are just my quick thoughts. I just wanted to share these thoughts before I turn over to Radha for her input, because we just thought that this is a very complex topic, and given that we don't have enough time, we can give an overview, but you know, because this is something you can talk for weeks. I mean, but Radha, over to you on that issue.
Thanks, Rajat. So I'll just add one point to what Rajat said. He gave a very practical view of the issues of insolvency in international arbitration. I'd like to go slightly to a more theoretical policy issue of what is the interplay between insolvency and arbitration, and why is this an issue in arbitrations? And that we basically see because of the competing policy interests between the two sets of legislations. while an international arbitration legislation encourages a more decentralized process, they want to focus on party autonomy and they want to give effect to parties' agreements. Insolvency has certain other policy interests, which is often competing, which is it wants to promote a more centralized process, and there's a focus on maximizing value of an insolvent company's assets, and the state steps in where a company cannot meet its obligations, and thereby there are policy objectives that it would override a dispute resolution agreement. And from this difference in policy interest stems the issues of whether an arbitration proceeding has to be stayed or not, or what happens to it when a party to an arbitration is insolvent, or what happens to an arbitration agreement when a party to the agreement is insolvent or on the brink of insolvency. So I just wanted to quickly touch upon the policy issues behind the whole issue of insolvency and arbitration, and I think Rajat has comprehensively summed up the practical issues of insolvency in an arbitration proceedings, and I'd like to leave it at that because I think we're at time, and I now hand over the floor back to CNICA to end the session. I think we're happy to take a couple of questions if time permits. If not, I think we're happy to take questions on email as well. And
no problem. There are a couple of questions. I think we can cover them up in within the time.
Sure.
We have one from our chairman. His question is, why India has not become the signatory of ICSID convention so far? We have been breaking our heads to find out why is it India not becoming one of the signatory. Any idea from your side? Maybe Rajat?
I think that's a really interesting question, because I would tell you that that's the exact same question that was asked to me 4 years ago by ICSID's Secretary General, and she and I met for coffee, and she asked me, why is India not signing when you see Nepal, when you see Pakistan, when you see Sri Lanka? What is stopping India? And I think she's really trying to convince India to sign the convention, and I think the answer is probably it's in their best interest not to sign it, because we saw what happened after 2G spectrum corruption issues that came out, and the massive wave of arbitration that hit the Indian government. And I think there are obviously conflicting studies which say whether signing treaties really increase foreign investment or not. So that's obviously up in the air. But I think third is, I think it's probably, if you are in the Indian government, it probably works in your best interest not to sign ICSID convention, because if you have an ICSID award, you can't even challenge the award in your own court. So any court, it has to be enforced. So I think there are fundamental questions, and I think there's a lot of movement I can tell you from ICSID itself to convince the Indian government. They actually thought about sending a delegation to the Indian government and align with Indian arbitration centers and think tanks to see if they can convince the Indian government or invite the Indian government officials to New York or DC to see if they can convince them to do so. But that's my take on it.
I know we in India project a lot of foreign investments, and we expect a lot of investments to come down. And in this scenario, we really understand that ICSID is one place where they have to get into convention to get the most of it. There's another question by Uday. He says, can you cite instances of Indian courts denying the use of documents obtained through the US discovery process under section 1782?
Yes, so I think I have not come across, as far as I remember, Indian courts are receptive to 1782 discovery. I have not seen any example, or as far as I'm aware, not seen any case where Indian courts have denied 1782 discovery. So and that makes sense because in New York, at least, we see oftentimes discovery requests from Indian courts asking for discovery from US courts. So it's a two-way street. So the reason why US courts do so is to encourage foreign courts to do the same. And so India is very, aggressive when it comes to foreign discovery, whether it's through the governmental process or through judicial process. So as far as I'm aware, I have not seen any example where Indian courts have denied using 1782 discovery.
Okay, there's another one also for, I think this is also for Mr. Rajat, by Mr. Tirupati. What are the set of criteria for filing discovery?
I mean, I think, so I walked through those statutory and discretionary factors. So it's basically a very simple application. You file a petition with the court. It's a miscellaneous petition. And I think you pay like $45 fee to the court, and you say in the petition that you satisfy those statutory factors, and you satisfy discretionary factors. And I'm happy to, if I can, Shell can email me and I can share my presentation, which lists those criteria. And the interesting thing is that this discovery process is supposed to be an ex parte proceeding. So in one of the cases, the petition was filed, and in 2 days, the court decided the petition and granted discovery. In contrast, the petition was filed before another judge, and she took a year and a half to decide the petition. So it depends on who you are before and your luck. But I think it's a very simple process. It's not difficult at all in terms of criteria. But I'm happy to share my presentation.
There's one from Mr. Abhay Kumar Jain. This is with respect to the insolvency aspect. His question reads like this. As per the insolvency bankruptcy law in India, the draft cross-border rules are notified, but we have not become the signatories to the cross-border insolvency. In that scenario, when CIRP, that is the Corporate Insolvency Resolution Professional, involves if the company having assets in more than one country and international arbitration clause, do you see any conflict between the two laws? So in general, what he wants to know is if there is a cross-border and where there is no agreement between the international clause, do you see any difficulty in it?
Radha, do you want to take it or?
Sure, I can address it first, and then you can add your thoughts to it. My own view is that there are a lot of complex conflict of law issues that come up when you're dealing with insolvency and arbitration, and often the tribunals would either look at the seat of arbitration, or they'd look at it's more that they would look at the seat of arbitration and what the international public policy over there would be in order to determine whether how the insolvency law would affect these arbitration proceedings, whether it should be stayed, whether it can go forward. So I think a lot would depend on these conflicts, what the tribunal arises after doing this conflict of law analysis. And if that's a pretty complex area, which like Rajat mentioned, we can go on for weeks talking about that. But I think for now it's suffice to understand that there are complex issues of conflict of laws that arise in this situation. And once the tribunal arrives at which law is applicable in the case of insolvency, because insolvency is often considered like an arbitrability issue. Once that is decided, then they would apply the international public policy of that law to see whether the insolvency law would permit it or not. The model on insolvency, of course, it goes in favor of staying in arbitration with foreign insolvency proceedings, but there are several things to be considered. Where is the insolvency proceedings initiated? What is the seat of arbitration? What is the governing law of the contract? And then we need to come to a kind of analysis of which law would be applicable to decide this particular issue. Rajat, do you want to add to that?
No, I think that's I think the fundamental question is always, where is the seat of arbitration? That's the first question. So you apply, for example, if the arbitration is seated in London, it's English Arbitration Act. And then the second question is, where is the insolvency proceedings ongoing? And so, like in one of the cases, it's going on in one of the African jurisdictions. And then when you litigate those issues before the tribunal, it doesn't really matter about the cross-border insolvency issues or anything else. What matters is where the company was incorporated, what's the law there, what's the law in the contract, and what's the law of the seat of arbitration. And, you know, I think it always helps when you have international law, because then you can always raise an argument based on access to justice. You can say that, you know, if you give importance to these liquidation proceedings, our access to justice, so the right to arbitration will be breached in international law. And that's something that the tribunals still look at. But anyways.
Okay, there are a few questions, and I would also like to know if anyone wants to ask your queries directly, they may raise your hands in the raise hand option. Meantime, we'll take up one question from Mr. Thakkar. I'll read out the question. In the US, will claim and rights to receive the payment to a claimant creditors in an arbitration be determined by an arbitrator? Will the arbitration proceedings be suspended, or will award or be restricted to payment outs fixed by the insolvency court for creditors in insolvency proceedings, which are for the benefit of all creditors?
So I can take that. I think in the US, and the answer is obviously that arbitration is by contract. So if in the US, we have US bankruptcy courts that decide bankruptcy petitions. But oftentimes, again, this is litigated in most of the common law jurisdictions. If you have a creditor files a bankruptcy petition and say that you did not pay this amount, say $1 million, but you dispute that amount and you say, I disagree with it, and in fact, there's an arbitration clause between the creditor and the debtor, the courts have stayed insolvency proceeding in the meantime and said, you go resolve this issue in arbitration. So if the parties have agreed to resolve any dispute, and depends on the arbitration clause, through arbitration, and in the meantime, the same creditor goes ahead and files a bankruptcy petition, that petition is oftentimes stayed in favor of arbitration. So that's how it works, at least most of the common law jurisdictions.
There's a question by Dr. A.L. Nagaraja. Your important challenging case in arbitration, maximum and minimum time period, which is possible. He wants to know the maximum time that has taken in an arbitration proceedings and the minimum time by which you could complete an arbitration proceedings.
I think I would tell you that it of course depends. So arbitration is just not any, black, as you can appreciate, it's not black and white. It depends on which arbitral rules you're looking at. Sometimes parties do not appreciate the arbitral rules, and there's some arbitral rules, for example, I think ICC rules that do provide for emergency arbitration. Similarly, I think SIAC rules in Singapore are really, really, friendly in terms of expediting the procedure. You can consolidate your claims, consolidate multiple arbitrations. So one, I think it depends on the arbitral rules. But that said, based on my experience, we have seen arbitrations, very complex arbitrations involving billion-dollar claims from beginning to end conclude in 3 years or less than 3 years. And when I'm talking about complex claims, I'm talking about like $2 million arbitration matters involving serious corruption issues against the sovereign state. So, and you know, those are really, really difficult claims to arbitrate, let alone you know, litigate. So it does take time, but I think 3 years is, I would say, in a ballpark figure, 3 years to 4 years time.
Well, as you rightly said, the time taken in an arbitration proceedings depends on the complexity and the various hurdles that it has to cross through. Vasavi Sridevi has got a question. When the party refused to produce document, even after the court order, what is the remedy available?
So in the U.S. courts, you, and Radha, of course, feel free to jump in. In the U.S. courts, you, if the party refuses to produce order, there's a remedy called a motion to compel. So you basically move the court to compel the other side to produce documents. You say, the court, look, you said produce these documents. They're refusing to produce these documents. We need an order to compel. So court will say, issue an order saying we compel that you produce these documents. And even if then they still refuse to produce documents, then there's obviously a contempt of court proceeding and you can go to jail. So, and the US courts are very serious about it. And if you're a very, you know, reputable, sophisticated business in the US or an individual, you don't even want an order against you that says you're compelled to produce. Oftentimes parties do produce it.
Yeah, there's one more question from our secretary. His question is whether the insolvency and arbitration will get into conflict. Like what he says is, does the opening of insolvency proceeding frustrates the parties' agreement to arbitrate their dispute?
Radha, do you want to take it? I don't want to.
Sorry, I couldn't hear that very well. Could you repeat that?
I'll repeat it. Does the opening of insolvency proceedings frustrate the parties' agreement to arbitrate their disputes?
Sure. Sorry. It depends in different jurisdictions. Of course, like in some jurisdictions, it does not frustrate it prima facie, but it needs to be seen whether the arbitration can go on or not, and it depends on what law is applicable. Again, going back to my earlier point about determining which law is applicable to determine the insolvency public policy that is applicable to that case. Once that is determined, then there are, of course, policies where insolvency proceedings can go on, but arbitrations can go on issues which are not relevant to the insolvency proceedings itself. For example, in the US, there is you usually require a stay only when the proceedings are core proceedings. That is where the federal bankruptcy code is the source of the claimant's right, or the right to remedy stems from the bankruptcy. In all other non-core proceedings, the insolvency, the arbitration can go on. So it depends on, and again, in Indian law, the IBC requires a moratorium against a corporate debtor. But if it's a claim which is being filed by the corporate debtor against somebody else, then there is no moratorium in those proceedings. So it depends on what the public policy of that country is and what the laws are. And I think a lot will turn on that issue.
And I think on that point, just quickly, I think it's, so the basic reason for that principle is, you know, when you look at insolvency and arbitration, the conflict is, if you're in insolvency, you want to protect the assets of the company, and you want to make sure that all pending cases are stayed. And oftentimes, depending on the jurisdiction, cases are automatically stayed. So what happens is, it depends on also your fee arrangement. So courts will say, look, we need to stay this arbitration because you're paying these lawyers, these really expensive law firms in UK or US. It's depleting the assets of the debtors. We need to protect the assets. Let's stay the arbitration. But if you can say that, look, Your Honor, there's no reason to stay this arbitration because, hey, this is third-party funded arbitration, or there's a contingency fee arrangement, you're not really depleting the assets of a debtor, it can go a different way. So I think if the fundamental premise is that let's protect the assets of the debtor, and I think it just depends on where, I would say it's just case-by-case basis. So, you know, the presumption is that insolvency and arbitration are in conflict, but I think it's also depends on so many other factors and case-by-case basis.
The next question is directed to you, Mr. Rajat, directly. It says, it's a generic question. Mr. Patra, he wants to know, is it in practice in US, apart from commercial issues, are family issues also being settled in arbitration proceedings?
I mean, I think you can settle any issue in arbitral proceeding as long as there's a contractual agreement between the parties. You can settle anything. Oftentimes, families do not enter into contracts. Like, for example, I do not, you know, enter into a contract with my dad or my mom, you know, because there's less formality and it's always, you know, word of mouth, and you trust a family member. So there's very few contracts, if any. And if there is a contract, I doubt there will be an arbitration clause in a clause in a family issues. But yes, you can resolve anything and everything in arbitration. So I think it just depends.
I think with this, we are coming down to the number of questions have been completed. And there are many appreciations for both of your presentation.
Thank you.
I think reading out is going to take the entire another half an hour. There's so much appreciation. With this, now I'll call upon, before that, I would like to announce one more thing, that is the next week's program. It will be by senior advocate R. Murari. He's an arbitration practitioner, well-versed in international arbitration. He is going to talk about appointment and qualification of arbitrator, changing scenario. You all know that how restrictions have been brought in the appointment of arbitrators. Now qualification for appointment has also been brought in. So in this light, this topic is going to create a lot of interest. So this is going to be on 7th of August at 4 p.m. As usual, our regular timing of 4 p.m. So I request all of you all to take the benefit of it. Now I call upon Priyadashini to render the vote of thanks.
So that was a very interesting, informative and thought-provoking presentation on the topic, Contemporary Issues in International Arbitration. The presentation was terse and dignified and was marked with sagacity, insight, acuteness and clarity. On behalf of CNICA and the Federation of Telangana Chambers of Commerce and Industry, I express my deep gratitude to Mr.RAJAT RANA and Ms.RADHA RAGHAVAN for accepting our invitation and sharing your time and wisdom amidst your busy schedule. Our heartfelt thanks to the wonderful participants who are instrumental in conducting this study series. We are grateful and thankful to our event associate, the Federation of Telangana Chambers of Commerce and Industry, for their graceful support and presence in making this event successful. My thanks to CNICA for giving me this opportunity to present the vote of thanks. Thank you one and all. Stay healthy, stay safe. Thank you.
Thank you.
Thank you.
Thank you.
Thank you. Thank you one and all. And with this, we'll end the meeting.
Thank you.